Hi, I'm attorney Renee Osipov with Chelle Law, and we assist dentists with employment agreement issues. Today, I'm discussing non-solicitation clauses versus non-compete clauses. What's the difference? What's the same? And what is typical in a dental employment agreement? So let's start with non-solicitation clauses. Non-solicitation clauses are a promise to not solicit patients, employees, third-party contractors for a specific period of time after your employment terminates with your dental practice. So what this looks like is you're either terminated or you terminate your employment with a practice and you leave. A non-solicitation clause states that for a period of time, typically 1 to 2 years, you are prohibited from reaching back out to those employees of the practice or to the patients that you had provided services for while you were an employee. Solicitation sometimes is defined in the agreement itself. It may say you're prohibited from directly soliciting or indirectly soliciting. If you see language like that, it's important to look to see within the employment agreement if it's defined. If it's not, it's customary that you should reach back out to that prospective employer and ask them to define those terms for you. Solicit, directly soliciting, normally means, and to me it means, reaching out to, enticing, encouraging those employees or patients to come with you. Now, if you're leaving a practice and a patient or an employee asks, where are you going? You can tell them. That's not solicitation. Solicitation is when you are the one who initiates the contact, you're reaching out, you're trying to poach those employees and those patients. That's when you would be in violation of a non-solicitation clause. Let's talk about general advertisement in relation to a non-solicitation clause. Sometimes this is directly outlined in the employment agreement, and it's always best that you start there first. Look at the clause itself. But if it just says you cannot solicit, normally general advertising is not considered solicitation. So that's billboards, social media, commercials, things like that. Not solicitation. You would only be in danger of violating a non-solicitation clause is if you reach directly out to those patients and employees. What this looks like, maybe you are sending patient list, you're getting their addresses and you're sending letters directly to them, or you're seeking them out directly, things like that. That would be solicitation. What are the consequences for a non-solicitation clause? Sometimes there's liquidated damages. So if you're found in violation, you may have to pay tens of thousands of dollars. And then normally I would say there is equitable relief. And what that looks like is if the practice feels like you're in violation of a non-solicitation clause, they can bring it before a judge. And what they would do is they would declare an injunction, or they may sign something like a restraining order, simply stating that you cannot solicit those patients. So that's typically what a non-solicitation clause looks like. They're fairly standard. Now let's look and talk about what is a non-compete clause. So a non-compete clause is similar to a non-solicitation clause because it's a promise not to do something. You're promising not to compete with a practice. Also, a non-compete clause is typically for the same period of time that the non-solicitation clause is for. So anywhere between even 6 months to 2 years. A non-compete clause also is going to have a restricted area. This could be miles. It could be city blocks. It could be counties. It could be municipalities. It just kind of depends on what state you're in and are you rural or are you city? If you're in New York City, I always use this example, you wouldn't use miles for a restricted area in a non-compete clause. you would likely use city blocks. Now, so we've talked about a non-solicitation clause and a non-compete clause. Again, with the non-compete clause, another similarity is how it's enforced. So again, there could be a liquidated damage clause, which would state if you were found in violation of the non-compete clause, you could pay tens of thousands of dollars. Also, there's equitable relief, which means that the practice would go before a judge. They would ask for an injunction or a temporary restraining order, which again is a piece of paper that states you cannot compete in that restricted area. Non-compete clauses can be a little bit more complicated than non-solicitation clauses. And what I mean by that is a non-compete can attach to multiple locations. So it could be your primary place that you provide services. It could be any location that you provide services, or it could be any location that's owned and operated by the practice. So again, the golden rule, you always want to refer back to your employment agreement to make sure you fully understand what you're signing, because this could have big implications in the future after your employment has terminated. Also, another similarity, non-solicitation clauses and non-compete clauses are typically found in the same part of the contract under the restrictive covenants. Restrictive covenants just means a promise not to do something. So you're promising not to compete with a practice, or you're promising not to solicit. If you have any questions or would like more information, or you want us to take a look at your employment agreement, please contact us at Chelle Law, CHELLE law.com. You can go to our website. We have tons of information about dental employment agreements, videos such as this one, and there's also our contact information. So you can set up an appointment with us, and we are happy to review your contract and give you lots of great feedback. Thank you.